If he files a civil suit after the limitation period, the suit may be dismissed as barred under Section 141, provided the action was in good faith. Section 142 of the Customs Act, 1962 Recovery of sums due to government. Statutory provision. Section 142 of the Customs Act, 1962 provides the statutory machinery for recovery of any sum due to the central government under the Customs Act when such amount is not paid voluntarily. Meaning in simple terms, if a person fails to pay customs dues, such as duty, penalty, fine, interest, or costs, customs can recover the amount forcibly using the methods prescribed in Section 142 without filing a civil suit. What amounts can be recovered? Any sum due includes customs duty, interest, penalty, redemption fine, costs or charges payable under the Act. Modes of recovery under Section 142. एक adjustment bata deduction. By deducting the amount from any money owed by the government to the defaulter, refunds, rebates, drawbacks. दो detention sale of goods. By detaining and selling goods belonging to the defaulter that are under customs control or subsequently come under customs control. 3 key cap recovery as arrears of land revenue. By certifying the amount to the district collector who recovers it as arrears of land revenue under state revenue laws. This can involve attachment of property, bank account attachment, auction of assets, 4 other prescribed modes. Recovery through rules and notifications framed under the Act, e.g., customs, attachment of property of defaulters, rules. Important safeguards principles. Recovery can start only after dues become final. Adjudication order passed and appeal period expired or appeal decided unless stayed. If pre-deposit is made in appeal. Recovery of the balance amount is stayed by law. Proportionality due process must be followed. Practical illustration. An importer is ordered to pay duty and penalty but does not pay even after the appeal period. Customs adjusts the amount against a pending refund and initiates recovery as arrears of land revenue under Section 142 for the balance. Section 143 of the Customs Act, 1962, power to allow import or export on execution of bond. Statutory provision. Section 143 of the Customs Act, 1962 empowers customs authorities to permit import or export of goods subject to execution of a bond with or without surety or security to ensure compliance with specified conditions. Meaning in simple terms, customs may allow goods to be imported or exported first, even when certain conditions are yet to be fulfilled or documents bata obligations are pending, provided the importer-exporter executes a bond promising to comply with conditions within a specified time and pay duty, interest, penalty, or other sums if conditions are violated. When is Section 143 used? Common situations include provisional clearance pending final assessment, conditional exemptions, e.g., end-use based exemptions, re-export obligations, export promotion schemes, advance authorization, EPCG, etc. Test or trial imports. Key features of Section 143. एक execution of bond. Importer-exporter executes a bond undertaking to observe conditions and to pay amounts due if conditions are breached. Customs may require surety and or security bank guarantee depending on risk. Though discretion of customs. Allowance under Section 143 is discretionary. Conditions may relate to use, disposal, or re-export of goods. Time limits for compliance. Production of proof documents. 3 consequences of breach. If conditions are not fulfilled, the bond can be enforced. Customs may recover duty, interest, and penalty under Section 142. Other actions, confiscation penalty, may follow as applicable. Safeguards practical points. Conditions must be clear, reasonable, and time-bound. Enforcement of bond must follow due process. Where compliance is shown, the bond should be discharged cancelled promptly. Practical illustration. An importer brings capital goods under a conditional exemption requiring use in manufacturing for 5 years. Customs allows clearance on execution of a bond under Section 143. If the importer violates the condition, Customs can invoke the bond and recover duty. Section 144 of the Customs Act, 1962, taking samples. Statutory provision. Section 144 of the Customs Act, 1962 empowers customs officers to take samples of imported or export goods for purposes such as examination, testing, valuation, classification, or verification of compliance with the Act and allied laws. Meaning in simple terms, when goods are presented to customs, officers may draw samples so that the goods can be examined physically, tested in laboratories, or verified for description, quality, composition, or standards, to correctly determine duty, eligibility of exemption, or legality of import-export. Key features of Section 144. Who can take samples? A proper officer of customs authorized under the Act. To keycap when can samples be taken? During import-export clearance, examination under assessment, investigation or adjudication, any proceeding where testing or verification is required. The purpose of sampling. Samples may be taken to determine classification, HSN-CTH, valuation, nature quality affecting value, eligibility of exemption, compliance with standards, BIS, FSSAI, drug controller, etc. Nature of goods, prohibited, restricted. Manner of taking samples. Samples must be taken in the prescribed manner, in the presence of the importer-exporter or their representative as practicable, with proper sealing and identification. A record panchnama is generally prepared. Cost of samples. The cost of samples is normally borne by the importer-exporter unless otherwise provided. Effect on clearance. Clearance may be withheld pending test results or allowed provisionally, often with bond guarantee under Section 143, depending on the case. Legal safeguards. Practical points. Sampling must be reasonable and proportionate, no excessive quantity. Results should be from a competent laboratory. Adverse test reports must be supplied to the noticee and can be contested. Improper sampling can be a valid ground of challenge in adjudication appeal. Practical illustration. Customs draws samples of imported chemicals to verify composition and classification. Pending lab results, goods may be cleared provisionally or detained. The sampling is carried out under Section 144. Section 145 of the Customs Act, 1962, owner to furnish facilities for examination. Statutory provision. Section 145 of the Customs Act, 1962 places a statutory duty on the owner, importer, exporter, or person in charge to provide all necessary facilities to customs officers for examination, testing, and inspection of goods. Meaning in simple terms, when customs needs to examine or test goods, the owner or person concerned must cooperate by providing labor, equipment, space, documents, and any other assistance required for proper examination of the goods. Customs is not required to arrange these facilities themselves. Who must provide facilities? Owner of the goods, or importer bata exporter, or person in charge, custodian, warehouse operator, carrier, etc. What facilities must be provided? Facilities may include opening packages bata containers, labor for unloading, unpacking, repacking, tools or equipment, forklifts, cranes, cutters, etc. Adequate space and lighting. Access to records and documents. Assistance during sampling under Section 144. Cost responsibility. All costs and expenses for providing such facilities are to be borne by the owner person concerned, not by customs. Consequences of non-compliance. Failure or refusal to provide facilities can lead to delay in clearance, adverse inference in adjudication, Possible penalty under relevant provisions, including Section 117, residual penalty. In extreme cases, action for obstruction, Section 133. Practical illustration. Customs directs an importer to open and unload containers for examination. The importer must arrange labor and equipment at his own cost under Section 145. Customs is not liable for such expenses. Section 146 of the Customs Act, 1962, Customs Brokers, Licensing Regulation. Statutory provision. Section 146 of the Customs Act, 1962 provides the legal framework for licensing, regulation, and control of customs brokers, earlier called clearing agents (CHAs), who transact business relating to the entry or departure of conveyances and the clearance of goods with customs. Meaning in simple terms: anyone who wants to act on behalf of importers-exporters before customs for filing documents, clearance, and compliance must hold a valid customs broker license issued under Section 146 and follow the prescribed rules. Who is a customs broker? A customs broker is a licensed professional who represents importers-exporters before customs, files bills of entry shipping bills, handles clearance, compliance, and coordination with customs authorities. Core components of Section 146. एक licensing requirement. No person can act as a customs broker without a license issued by the Principal Commissioner of Customs. Licensing is governed by Customs Brokers Licensing Regulations, CBLR, issued under the Act. Though eligibility conditions. License is granted subject to qualifications and examinations, financial security, bank guarantee, etc. Fit and proper criteria. Compliance with CBLR conditions. 3 obligations of customs brokers. Customs brokers must verify the identity and antecedents of clients, KYC. Advise clients correctly on customs law. Exercise due diligence in filing declarations. Maintain records and make them available to customs. Not abet any violation of the Act. Failure can attract penalty, suspension, or revocation of license. Char disciplinary control. The licensing authority may suspend the license in urgent cases, revoke the license after inquiry, impose penalties for violations of CBLR. Due process, notice, hearing, inquiry is mandatory. 5 liability of customs brokers. Customs brokers can be proceeded against under civil penalty provisions, e.g., Section 112. Disciplinary action under CBLR. Criminal provisions if mens rea abatement is proved. Practical importance. Section 146 ensures professional standards in customs clearance, accountability of intermediaries, trade facilitation with compliance. For importers-exporters, choosing a compliant customs broker reduces risk of disputes and penalties. Section 147 of the Customs Act, 1962, liability of principal and agent. Statutory provision. Section 147 of the Customs Act, 1962 lays down the rule of joint and several liability between a principal, importer-exporter, and their agent for acts done under the Customs Act. Meaning in simple terms: when a person, agent, acts on behalf of another, principal, in customs matters, both the principal and the agent are liable for compliance with customs law. Customs can proceed against either or both for duty, penalty, fine, or other liabilities arising from such acts. Appointment of an agent does not absolve the principal of responsibility. Who is an agent under Section 147? Includes customs broker, licensed under Section 146. Clearing forwarding agents. Employees or representatives authorized to act. Any person who acts for or on behalf of the importer-exporter. Core rules under Section 147. 1 key cap acts of agent acts of principal. Anything done or omitted by the agent is deemed to have been done by the principal, and the agent is also personally liable, though joint and several liability. Customs may recover dues from the principal or recover dues from the agent or proceed against both together. Teen scope of liability applies to duty, interest, penalty, redemption fine, any sum payable under the Act. 4 key cap internal arrangements not binding on customs. Any private agreement between principal and agent. E.g., indemnity clause, responsibility split. Does not bind customs. Such arrangements are relevant only inter se between the parties. Important safeguards judicial principles. Liability of agent typically depends on authority to act and knowledge involvement, especially for penalties. Mechanical penalization of agents without evidence of role knowledge is discouraged by courts. Customs brokers may still face disciplinary action under CBLR, independent of Section 147. Practical illustration. A customs broker files a bill of entry on behalf of an importer with wrong classification. Customs may demand duty from the importer and impose penalty on the broker if knowledge abatement is proved, relying on Section 147 for joint liability. Section 148 of the Customs Act 1962, liability of agents of the owner or person in charge of a conveyance. Statutory provision. Section 148 of the Customs Act 1962 provides that agents of the owner or person in charge of a conveyance, ship, aircraft, vehicle, etc. are liable for customs obligations in the same manner as the principal, unless otherwise proved. Meaning in simple terms, if an agent acts on behalf of the owner or the person in charge of a conveyance, e.g., master of a vessel, airline operator, then customs can treat the agent as if they were the principal for purposes of duty, penalty, other obligations under the Act. This ensures customs can enforce compliance even when the principal is absent or overseas. Who is covered as an agent? Includes shipping agents, airline agents, steamer agents, authorized representatives handling arrival-departure formalities, any person authorized to act for the owner person in charge of a conveyance. Core rules under Section 148. एक agent deemed liable. The agent is liable for compliance with customs provisions as if they were the owner person in charge. Though joint and several liability, customs may proceed against the principal or the agent or both for recovery of dues or penalties. Teen defense available to agent. The agent can escape liability if they prove that the contravention occurred without their knowledge or they exercised due diligence and acted within authority. Burden to prove this defense lies on the agent. Scope of liability applies to import-export documentation, filing of manifests, compliance with arrival-departure procedures, duties, penalties, and other sums payable under the Act. Practical illustration. A shipping line's agent files an incorrect import general manifest IGM. Even though the vessel owner is abroad, customs can proceed against the agent under Section 148 for penalties or dues. Section 149 of the Customs Act 1962, Amendment of Documents. Statutory provision. Section 149 of the Customs Act 1962 empowers customs authorities to permit amendment of documents, such as bills of entry, shipping bills, manifests, etc., after they have been presented to customs, subject to conditions. Meaning in simple terms, if an importer-exporter or their agent has made an error or omission in customs documents, customs may allow correction, amendment, even after filing, provided the request is supported by proper evidence and satisfies legal requirements. What documents can be amended? Commonly amended documents include bill of entry, shipping bill, import bata export manifests, invoices, packing lists as part of assessment records. Key conditions for allowing amendment. 1 key cap evidence must be in existence at the relevant time. Amendment can be allowed only on the basis of documentary evidence that existed at the time the document was originally filed and was not created later to suit the case. This is the most critical condition under Section 149. Though discretion of proper officer. Amendment is not automatic. The proper officer must be satisfied that the request is bona fide and it does not defeat the provisions of the Act. 3 before versus after clearance. Stage. Position. Before clearance. Amendments are more liberally allowed. After clearance. Allowed only if supported by contemporaneous evidence. Char nature of amendment. Permissible. Clerical errors. Typographical mistakes. Wrong codes, descriptions, values, if evidence exists. Not permissible. Changes based on post-import-export events. Amendments to fabricate eligibility for exemption incentives. Special note, export incentive cases. Amendments affecting duty drawback, export incentives, Mace Rotep, etc. are examined very strictly, and Section 149 is often litigated in such cases. Practical illustration. An importer wrongly mentions the country of origin in the bill of entry due to a clerical error. Since the correct certificate of origin existed at the time of import, customs may allow amendment under Section 149. Judicial principles well settled. Courts have held that Section 149 is a beneficial provision, but it cannot be used to rewrite history. Contemporaneous documentary evidence is mandatory. Discretion must be exercised reasonably and judiciously. Section 150 of the Customs Act, 1962, Procedure for Sale of Goods and Application of Sale Proceeds. Statutory provision. Section 150 of the Customs Act, 1962 lays down how customs must sell goods that come into its possession, e.g., confiscated, abandoned, or uncleared goods, and how the sale proceeds are to be applied. Meaning in simple terms, when goods are lawfully sold by customs because they are confiscated, not cleared, or cannot be returned, Section 150 prescribes the order in which the sale proceeds are to be appropriated and who gets paid first and who gets any balance. When does Section 150 apply? Goods are confiscated and vest in government, Section 126, or uncleared, abandoned at port warehouse, or sold due to perishability, hazard, or prolonged detention, or sold after non-payment of dues. Order of application of sale proceeds, very important. The sale proceeds are applied in the following statutory priority. 1. Expenses of sale. Costs incurred by customs for sale auction, storage, handling, custody and disposal. 2. Customs dues. Customs duty, interest, penalty, redemption fine, any other sum due under the Act. 3. Key cap other government dues, if any. Dues payable to central government or state government as legally recoverable. Char balance, if any. The remaining amount, if any, is paid to the owner of the goods or to the person legally entitled to receive it. Important legal points. Sale does not eliminate liability. If sale proceeds are insufficient, customs may recover the balance under Section 142. Right to balance. If proceeds exceed dues, the owner is entitled to the surplus. Due process. Sale must follow prescribed procedure, notice, auction rules, transparency. Practical illustration. Customs auctions confiscated electronics for 10 lakh rupees. 1 rupia lakh auction storage expenses. 6 rupees lakh duty, penalty, fine. 3 lakh rupees returned to the importer if legally entitled. Section 151 of the Customs Act, 1962, Disposal of Perishable or Hazardous Goods. Statutory provision. Section 151 of the Customs Act, 1962 empowers customs authorities to dispose of goods immediately when they are perishable, hazardous, or likely to lose value, without waiting for completion of adjudication. Meaning in simple terms, when goods may perish or decay, or are hazardous, or are likely to deteriorate or lose value rapidly, customs can sell, destroy, or otherwise dispose of them promptly, even if legal proceedings, adjudication appeal, are still pending. This avoids risk, loss, and public danger. When can Section 151 be invoked? Goods are perishable, food items, flowers, fruits. Hazardous, chemicals, explosives, toxic substances. Likely to depreciate quickly, live animals, sensitive goods. Modes of disposal. Customs may sell the goods, auction tender. Destroy the goods where sale is unsafe or illegal. Dispose of them in any manner prescribed by rules or notifications. Safeguards important points. Disposal must be as per prescribed procedure. Documented properly. Inventory, Panchnama. Reasonable and proportionate. Adjudication not barred. Disposal does not end proceedings. Rights and liabilities, duty, penalty, fine are decided later. Sale proceeds. Handled as per Section 150, expenses dues balance. Practical illustration. Customs seizes a consignment of perishable food items suspected of misdeclaration. To prevent spoilage, Customs sells the goods immediately under Section 151 and adjudication continues later. Section 152 of the Customs Act 1962 power to make rules. Statutory provision. Section 152 of the Customs Act 1962 empowers the central government to make rules for carrying out the purposes of the Act. Meaning in simple terms, Parliament lays down the framework in the Customs Act, but day-to-day procedures and details are prescribed through rules. Section 152 gives the central government the legal authority to frame those rules. Without Section 152, many operational aspects of customs would not function smoothly. Scope of rule-making power. Under Section 152, rules may be made on matters such as procedures for import, export, transit, warehousing, forms, formats, and declarations, conditions, safeguards, and compliance requirements, time limits, records, and documentation, disposal, sale, custody, and handling of goods, recovery procedures, and enforcement mechanisms. The list is illustrative, not exhaustive. Nature of rules made under Section 152. Rules are subordinate, delegated, legislation. Binding and enforceable, like the Act itself. However, rules cannot override or contradict the Customs Act. If there is conflict, the Act prevails. Parliamentary control, important. Rules made under Section 152 must be laid before both houses of Parliament. Parliament may modify the rules or annul them. This ensures democratic oversight over delegated legislation. Examples of rules made under Section 152. Customs, import of goods at concessional rate of duty, rules. Customs, attachment of property of defaulters, rules. Customs, provisional duty assessment, rules. Customs valuation rules. Baggage rules. All derive authority from Section 152 or allied rulemaking sections. Practical importance. Enables flexibility to update procedures without amending the Act. Respond quickly to trade, technology, and enforcement needs. Ensures uniformity in customs operations across India. Section 153 of the Customs Act 1962 Service of Orders, Decisions, Notices, etc. Statutory provision. Section 153 of the Customs Act 1962 prescribes the legally valid modes for service of orders, decisions, notices, summons and other communications issued under the Customs Act. Proper service under Section 153 is crucial because limitation periods, appeal, compliance, recovery start from the date of service. Meaning in simple terms, Customs must serve documents in a legally recognized manner. If service is not done as per Section 153, the action, demand, penalty, recovery, appeal limitation can be challenged as invalid. Modes of service recognized under Section 153. Service may be effected by any of the following methods. 1 key cap by tendering or sending by registered speed post. Delivered to the person concerned or their authorized agent or at the last known address. Postal service is the most common mode. To key cap by courier electronic means as notified. Includes email, electronic portal uploads, IceGate Customs Portal. Valid only if notified prescribed by rules or notifications. 3 key cap by affixing at a conspicuous place. If service by normal modes is not possible, notice order may be affixed at the last known place of business or residence. This is a substituted service, used as a last resort. 4 key cap by publication, in rare cases. Through newspapers or official publication, where permitted and justified. Service on company firm agent. Service is valid if made on director, partner, principal officer, or authorized customs broker agent, where applicable. Legal importance of Section 153, very critical. For customs. Establishes proof of communication. Enables recovery under Section 142. Enforcement of orders. Start of limitation period. For importer-exporter notice. Improper service can be a strong technical defense. Appeal limitation may not start. Recovery can be stayed. Ex parte orders can be challenged. Common practical issues. Order uploaded on portal, but no email intimation. Notice sent to old address. Service claimed without postal proof. Affixture done without showing prior failure of normal service. Courts often hold such service to be invalid. Practical illustration. Customs claims that an adjudication order was served by post, but cannot produce postal acknowledgement or tracking. The assessee challenges recovery, arguing non-service under Section 153. Recovery action may be quashed. Section 154 of the Customs Act, 1962, correction of clerical or arithmetical mistakes. Statutory provision. Section 154 of the Customs Act, 1962 empowers customs authorities to correct clerical or arithmetical mistakes in any decision, order, notice, summons, or other document issued under the Act. Meaning in simple terms, if there's a minor, obvious mistake like a typing error, calculation error, or accidental slip, customs can correct it at any time, either on their own or on being pointed out by the affected person. Section 154 is meant for rectification, not for review or re-adjudication. What kind of errors can be corrected? Permissible corrections. Typographical errors, wrong date, name, section number. Arithmetical mistakes, wrong total, calculation of duty interest. Accidental slips or omissions. Clerical mistakes apparent on the face of record. Example, duty calculated as 1,20,000 rupees instead of 1,02,000 rupee due to totaling error. Not permissible under Section 141. Change in classification. Change in valuation. Reinterpretation of law. Modification of findings or reasoning. Review of adjudication order on merits. Such changes require appeal or review, not Section 154. Who can invoke Section 141? Customs Authority, suo motu, or importer-exporter notice by filing a rectification request. There is no prescribed time limit, but it must relate to a clear and obvious error. Procedure safeguards. Correction must be limited to the mistake, clearly identifiable from records. If correction increases liability, principles of natural justice may apply. A brief order endorsement recording the correction is usually made. Section 154 versus Section 149. Very important distinction. Aspect. Section 149. Section 151 applies to amendment of documents, correction of mistakes. Who applies? Importer, exporter, customs or affected person. Evidence. Contemporaneous documents. Existing record. Nature. Substantive amendment. Clerical arithmetical only. Practical illustration. An adjudication order mentions Section 111(d) instead of Section 111(m) due to a typing error. Customs can correct this under Section 154 without issuing a fresh order. Section 155 of the Customs Act 1962 Protection of action taken in good faith. Statutory provision. Section 155 of the Customs Act 1962 grants legal protection, immunity, to the central government, customs officers, and other persons for actions taken in good faith under the Act or the rules. Meaning in simple terms, if customs authorities or persons acting under the Act act honestly, without malice, and in pursuance of the Customs Act or rules, then no suit, prosecution, or other legal proceeding can be initiated against them for such actions, even if some loss or inconvenience is caused. This section protects bona fide official actions, not abuse of power. Who gets protection under Section 155? Central government. Customs officers. Any other person acting under the Act or under rules orders made under the Act, e.g., custodians, authorized persons acting under customs directions. Scope of protection. One key cap acts done in good faith. Protection applies only if the act is done honestly and believed to be lawful at the time and within the scope of the Customs Act or rules. Though type of proceedings barred: civil suits, criminal prosecution, other legal proceedings. All are barred if good faith is established. What is not protected? Section 155 does not protect actions that are mala fide with bad intention, without jurisdiction, for personal gain, abusive or vindictive, unrelated to official duty. In such cases, courts can lift the protection and allow proceedings to continue. Relationship with other protective provisions. Section. Protection. 140. Sanction to prosecute customs officers. 141. Limitation of suits proceedings. 155. Immunity for good faith actions. CRPC 197. Protection of public servants. Practical illustration. A customs officer seizes goods believing them to be smuggled. Later, adjudication drops the case. Since the seizure was done honestly and in good faith, the officer is protected under Section 155 from personal liability. Section 156 of the Customs Act 1962 Delegation of Powers. Statutory provision. Section 156 of the Customs Act 1962 empowers the central government to delegate its powers under the Act to specified authorities or officers subject to conditions and limitations. Meaning in simple terms, the Customs Act gives many powers to the central government. Since the government cannot exercise all powers directly, Section 156 allows it to delegate those powers to CBIC, Principal Commissioners, Bata Commissioners, other customs officers, so that the Act can be administered efficiently. Delegation ensures smooth, day-to-day functioning of customs administration. Key features of Section 156. Who can delegate? The central government only. To key cap to whom can powers be delegated? CBIC, Central Board of Indirect Taxes Customs. Principal Commissioner, Commissioner of Customs. Other customs officers or authorities, as specified by notification. 3 mode of delegation. Delegation is done by notification in the Official Gazette. The notification specifies Which powers are delegated? To whom? Conditions or limitations, if any. 4. Extent of delegation. Delegated authority can exercise only those powers expressly delegated, only within the limits mentioned in the notification. Any action beyond delegated power is without jurisdiction and liable to be struck down. Practical importance. Enables issuance of notifications, exemptions, procedures, efficient enforcement and administration, prevents concentration of powers at one level, forms the legal basis for many CBIC notifications and instructions, safeguards legal principles. Delegation must be within the framework of the Act, not amount to excessive delegation. Delegated legislation actions can be judicially reviewed, quashed if ultra vires the Act or notification. Practical illustration. The central government delegates the power to issue certain procedural notifications to the CBIC. CBIC issues a notification within the delegated scope. Such action is valid under Section 156. Section 157 of the Customs Act 1962 power to make regulations. Statutory provision. Section 157 of the Customs Act 1962 empowers the Central Board of Indirect Taxes Customs, CBIC, to make regulations for carrying out the purposes of the Act consistent with the Act and the rules. Meaning in simple terms, while Parliament makes the Act and Central Government makes rules, Section 152, the CBIC is authorized under Section 157 to make detailed procedural regulations needed for day-to-day customs administration. Regulations deal with operational details, not policy. Who makes regulations? CBIC, the board, only. By notification in the Official Gazette. Scope of regulations under Section 157. Regulations may be made for matters such as procedure for filing bills of entry shipping bills, electronic filing systems, IceGate, digital signatures, forms, formats, and declarations, manner of assessment, clearance, and examination, custody, storage, and handling of goods, conduct of customs officers and procedural compliance. Regulations supplement the Act and rules. Legal hierarchy, very important. Level. Instrument. 1. Customs Act 1962. 2. Rules, Section 152 Central Government. 3. Regulations, Section 157 CBIC. 4. Circulars bata instructions, administrative. Regulations cannot override the Act or rules. Difference between rules regulations. Aspect. Rules, Sec. 152. Regulations, Sec. 157. Made by Central Government. CBIC. Nature. Subordinate legislation. Procedural subordinate legislation. Scope. Broader. Detailed but operational. Gazette notification. Yes. Yes. Parliamentary control. Regulations must be laid before Parliament. Parliament may modify or annul them. Similar to rules, ensuring oversight. Practical importance. Provides flexibility to update procedures quickly. Enables digital customs processes, trade facilitation measures, risk-based assessment systems. Forms the backbone of modern customs operations. Practical illustration. CBIC issues regulations prescribing electronic filing and verification of bills of entry. These are valid as regulations under Section 157, so long as they align with the Act and rules. Section 158 of the Customs Act 1962 repeal and saving. Statutory provision. Section 158 of the Customs Act 1962 deals with the repeal of earlier customs laws and the saving, continuance, of actions taken under those repealed laws. Meaning in simple terms, when the Customs Act 1962 came into force, it repealed earlier customs enactments. Section 158 ensures that past actions taken under the old laws do not become invalid and ongoing rights, liabilities, proceedings, and penalties continue unaffected. In short, old law goes, but lawful past actions stay valid. What does Section 158 do? एक repeal of earlier laws. The earlier customs law, S, enforced before 1960 to stand repealed. Though saving clause, very important. Despite repeal, anything done or omitted under the old law is deemed to have been done under the Customs Act 1962, if not inconsistent. This includes notifications, rules, orders, licenses, permissions, investigations, adjudications, penalties, prosecutions, rights and liabilities already accrued, continuation of proceedings, any suit, appeal, inquiry, or prosecution started under the old law may be continued and concluded as if the new act had not adversely affected it. Why Section 158 is necessary? Without a saving clause, repeal of an old law could wipe out pending cases, invalidate actions already taken, create legal chaos. Section 158 ensures legal continuity and certainty. Practical illustration. An investigation for customs duty evasion was initiated under the old customs law before 1962. Even after repeal, the proceeding can continue lawfully due to Section 158. Relationship with general law. Section 158 operates in addition to Section 6 of the General Clauses Act 1897, General Saving on Repeal. It specifically tailors the saving effect for customs matters. Section 159 of the Customs Act 1962, laying of rules, regulations and notifications before Parliament. Statutory provision. Section 159 of the Customs Act 1962 mandates parliamentary oversight over rules, regulations and certain notifications made under the Act by requiring them to be laid before both houses of Parliament. Meaning in simple terms, whenever the government or CBIC makes rules, regulations, notifications under the Customs Act, they must be placed before Parliament. Parliament has the power to approve, modify, or annul them. This ensures democratic control over delegated, subordinate legislation. What instruments are covered? Section 159 applies to rules made by the central government, e.g., under Section 152. Regulations made by CBIC, e.g., under Section 157. Notifications issued under powers delegated by the Act, where specified. Procedure prescribed under Section 159. एक laying before Parliament. The rule regulation notification must be laid before the Lok Sabha and the Rajya Sabha for a total period of 30 days, which may be spread over one or more sessions. Though Parliament's power, during or after this period. If both houses agree, the instrument may be modified or annulled, cancelled. 3 key cap effect of modification or annulment. Any modification or annulment applies prospectively, future effect. Does not invalidate actions already taken under the instrument before such modification annulment. This protects past actions taken in good faith. Why Section 159 is important? Prevents unchecked executive lawmaking. Maintains balance between legislature and executive. Ensures transparency, accountability, constitutionality of subordinate legislation. Practical illustration. CBIC issues regulations prescribing a new electronic filing procedure. These regulations are laid before Parliament under Section 159. If Parliament later modifies them, filings already made remain valid. Section 160 of the Customs Act 1962, Removal of Difficulties. Statutory provision. Section 160 of the Customs Act 1962 empowers the central government to remove difficulties that may arise in giving effect to the provisions of the Act by issuing appropriate orders. Meaning in simple terms, when the Customs Act is implemented, practical or procedural difficulties may arise that were not anticipated by Parliament. Section 160 allows the central government to smoothen implementation by issuing orders to clarify, adapt, or adjust procedures without changing the substance of the law. It is a temporary, facilitative power, not a lawmaking power. Key features of Section 160. One key cap, who can exercise the power? Central government only. Though purpose of the power. to remove difficulties in implementing the Act, to ensure smooth transition, practical operability, administrative clarity. It is used when strict application of the Act creates unintended hardship or ambiguity. The mode of exercise: by issuing an order published in the Official Gazette. Such order must be consistent with the Act, not alter or override the Act. Char time limitation, very important. The power under Section 160 can be exercised only within 2 years from the date on which the relevant provision of the Act comes into force. After this period, no removal of difficulty order can be issued. 5. Parliamentary control. Orders issued under Section 160 must be laid before Parliament. Parliament may modify or annul them. What Section 160 does not permit: it cannot be used to create new rights or liabilities, impose new taxes or penalties, amend substantive provisions of the Act, bypass Parliament. Courts strictly police misuse of this power. Practical illustration: a new customs provision comes into force, but the transition creates procedural confusion for pending cases. The central government issues a removal of difficulties order under Section 160 to clarify how pending cases will be handled. Section 161 of the Customs Act, 1962, repeal of notifications, orders, etc. Statutory provision. Section 161 of the Customs Act, 1962 deals with the repeal of notifications, orders, rules, or regulations issued under the Act and lays down the saving effect of such repeal. Meaning in simple terms: when the government withdraws, replaces, or repeals a customs notification, rule, regulation, or order, Section 161 ensures that actions already taken under the old instrument remain valid unless the repealing instrument expressly provides otherwise. Repeal does not undo the past. What Section 161 provides: 1 key cap power to repeal rescind. The authority that issued a notification, rule, regulation, or order can rescind or amend it, usually by issuing a fresh notification, though saving of past actions, unless a contrary intention appears. Repeal does not affect anything already done, any right, privilege, obligation, or liability acquired, any penalty incurred, any investigation, legal proceeding, or remedy already initiated. These continue as if the repeal had not taken place. 3. Continuation of proceedings. Investigations, adjudications, demands, or prosecutions initiated under the old notification order can be continued and concluded even after repeal. Why Section 161 is important: prevents escape from liability merely because a notification is withdrawn, legal vacuum or uncertainty, ensures continuity and certainty in customs administration, protection of government revenue. Practical illustration: an exemption notification is withdrawn with effect from 1st July. Imports made before 1st July in violation of conditions can still be proceeded against because Section 161 saves past liabilities. Section 162 of the Customs Act, 1962, power to make regulations for transitory provisions. Statutory provision. Section 162 of the Customs Act, 1962, empowers the central government to make transitory, transitional provisions to smoothly apply the Customs Act to situations arising during transition from old provisions to new ones. Meaning in simple terms: when new provisions are introduced or existing provisions are amended, repealed, or replaced, there may be practical gaps or transitional issues, pending cases, ongoing imports, old licenses, etc. Section 162 allows the government to issue regulations orders to ensure a smooth transition without hardship or confusion. Think of it as a bridge provision to handle changeover situations. What are transitory provisions? These are temporary arrangements to deal with pending assessments or appeals, ongoing investigations, existing licenses, bonds, or permissions, imports, exports in process at the time of change, rights and liabilities arising before or during transition. Key features of Section 162. 1 key cap: who can exercise the power? Central government. 2 purpose: 2. Remove practical difficulties during transition. Clarify applicability of old versus new provisions. Avoid legal vacuum or hardship. 3. Nature of power. Limited and transitional. Cannot alter substantive rights permanently. Override the Act itself. 4. Publication control. Orders regulations must be published in the official gazette, laid before Parliament, ensuring oversight. Practical illustration. A new customs amendment changes valuation rules from a particular date. Pending assessments straddling the old and new regime create confusion. The government issues a transitory provision under Section 160 to clarifying how such cases will be finalized.